All right, for this lesson, what we're going to be doing is we're going to be looking at some of the basic concepts of what happens with the Supreme Court. The Supreme Court is the ultimate court of the land. So it is the highest level of court that you can get to in the United States. There's nothing beyond the Supreme Court. So when the Supreme Court makes a decision, that's what the decision is. There are 9 judges that make up the Supreme Court. These justices then hold their positions for life. And there's a reason why they hold these positions for life. It's to kind of insulate them from a lot of the political things that are going on within government. It's to stop it from, say, you losing your position because you don't back one party or the other, to have an inconsistency in what's going on in the court, so that as each party takes power, that they can hire and fire justices as they see fit. All right. By getting them out of this political game, it should therefore allow our justices to look at what is going on in the Supreme Court based upon the constitutionality of the law rather than from a partisan point of view. All right, so that is the theoretical concept behind why judges hold their positions for life. All right. Justices are appointed to the Supreme Court by the President of the United States with Senate approval, and it is the Judiciary Committee that is going to approve these appointments. The President receives help from the Attorney General and other Justice Department officials. So the AG usually consults with the legal community and proposes a list of possible candidates for the President to consider. All right. So then the ABA, the American Bar Association, is consulted by every president concerning almost every federal judicial appointment. When they go through and they go to make these appointments, the ABA will rate each candidate is either well qualified, qualified, or not qualified. And you are very rarely, if ever, going to draw anybody from outside of that well-qualified pool. All right, so let's look at case procedures. How are cases heard in the Supreme Court? First, the court is going to determine which cases it's going to hear. All right, 99% of the cases that are ever appealed to the Supreme Court are not heard. All right, and we're going to look at some of the different criteria and things like that later on for how the Supreme Court determines what cases that they're going to hear. But you can pretty much be guaranteed that if anybody ever screams at you, I'm going to take you to the Supreme Court, that they're wrong. All right, 99% of the court cases that are ever appealed to the Supreme Court are never heard. Once the court determines what cases that they're going to hear, lawyers will then submit something known as a brief. A brief is full of relevant facts and precedents that support their side of the case. They're going to look at other cases that the Supreme Court has heard, and they're going to use those cases as an argument for why their side is correct. They are going to look at other statutes and things like that, and they're going to try and use those as a marker for why they're correct. All right. Not only are lawyers going to submit briefs, there are going to be other people that have a vested interest in what's going to happen in that case. They're going to submit briefs as well. The briefs that are submitted by these individuals are known as amicus curiae. And amicus curiae means friend of the court. All right, so say it was a gun legislation case. The NRA is almost undoubtedly going to submit an amicus curiae brief that is designed to argue for why a pro-gun stance is a good thing. If it was something that had to do with abortion, then Planned Parenthood is almost undoubtedly going to submit an amicus curiae brief that is going to explain why women should be able to have a choice in making that decision rather than the government dictating what they're allowed to do. All right, so these are subtle ways of lobbying the court and trying to get the things that you want to have happen. Then oral arguments are heard. So after these briefs are read through and the justices have an opportunity to kind of do their own research and come up with a lot of what they're thinking, and then to be able to generate questions for deficiencies that they see in the case, each side is given 30 minutes to provide an oral argument to the court. So on the podium that they're at, there are going to be different lights that are going to show the person who's arguing as to when their time is almost up and when their argument is over. All right, so they get 30 minutes. In that 30 minutes, the Supreme Court justices have the opportunity to interrupt that individual who's giving that oral argument at any time that they want to be able to ask a question or to try and push for additional information. On Fridays, the justices meet in conference to discuss the cases. So you can hear cases Monday through Thursday, and then on Fridays, the justices are going to meet to discuss the cases that they've heard throughout the week. On these Friday meetings, they're going to meet for 6 to 8 hours, and they're going to debate the cases. No minutes are kept, and when we talk about minutes in a meeting, it is an actual transcription of what each individual said during the meeting. So no minutes are kept. And actually, the justices are pretty secretive about what goes on in those meetings. Even when interviews are done with former justices or even current justices, they're very, very kind of hesitant to talk about anything that happens in those meetings or what's actually said during those meetings. It's very much a club, and there have been very few people who have been part of that concept of being a Supreme Court justice. So they're very kind of protective over what goes on in those meetings. Once it starts, the Chief Justice summarizes the case and offers recommendations for handling the case. So kind of recommendations for how the debate should take place and kind of set up structure and things like that. Each case only gets about 30 minutes of debate. You have to realize that a lot of the decision decision-making process is done reading the briefs and doing the research before the case is even heard. They get the writ of certiorari, which allows them to see what has happened in the previous hearings of the case. They all know law, obviously, because they're lawyers and they are justices and things like that. So there's a lot of legwork that's done before these arguments even take place. After the 30 minutes of debate, and depending on the level of the case, there is more debate more debate that can be done, but generally only about 30 minutes takes place. In the order of seniority, each justice votes on the case. A majority must be held in order to pass judgment on a case. So if we look at the original makeup of the Supreme Court, there were only 4 members. So you could have had a tie. You could still have a tie even now with there being 9 justices, because you could abstain from voting. That actually happened with a recent case. Elena Kagan, who is the most recent appointee to the Supreme Court, she had a case in which she had previously worked on the case on a lower level, and because of that, she abstained from voting as a Supreme Court justice because she had already had a predisposition as to what she thought the case should be heard as, and whether or not it should be upheld or overturned. So in the instance of a tie within the Supreme Court, what happens is that it is the previous decision of the lower court that is upheld. After the debate is done and the decision is made, then justices write their opinions on what the case should be. And the opinion states the facts of the case, it announces the court's ruling, and it explains its reasoning in reaching the decision. Alright, so there are 4 types of opinions that we can see. A unanimous decision is when all justices vote to uphold or all justices vote to overturn. Alright, so all 9 of them are going to vote one way or the other. A majority opinion takes place when the winning side writes their opinion on what happens. So a 5-4, a 6-3, a 7-2, an 8-1, it's that higher number that's going to be able to write that majority opinion. A concurring opinion takes place when you agree with the outcome of a case, but you agree so for a different reason. Alright, so as an example, say everybody in the class, their favorite color is blue. But some people like blue for one reason, and some people like blue for another. Those are concurring opinions. Or say we like pizza. Well, I like pizza because of the cheese. Well, I like pizza because of the pepperoni. We like pizza, but we like pizza for different reasons. So that's a concurring opinion. And then the dissenting opinion is the opinion of the justices on the losing side. Alright. Approximately 8,000 cases are submitted annually for the Supreme Court to review. 99% of these cases are denied and not heard by the court. So, the likelihood of your case ever making it to the Supreme Court level is very, very, very low. If 4 justices agree to hear the case, then it can be scheduled for oral arguments. A writ of certiorari is then issued to the lower courts. So whatever district court or appellate court heard that before, they're going to get a writ of certiorari, and that is a demand that or a request that the information that was heard in the previous case be turned over to the Supreme Court. The Solicitor General can have an impact on what the case is that the Supreme Court hears. The Solicitor General is in charge of deciding whether to appeal cases that the government has lost, to review and modify the briefs presented in government appeals, to represent the government before the Supreme Court, and to submit amicus curiae briefs on behalf of a litigant in a case that the government has an interest in. So if the Solicitor General gets involved in these different types of things, then there's a more likely chance that it can possibly be heard, but there's definitely no guarantee. So courts have a minor role in setting foreign policy, and we're not going to really spend a whole bunch of time talking about that, so just look over that on your own there. But there are certain criteria that must be met for cases to be heard in the Supreme Court. And if it doesn't meet these criteria, then there's absolutely no way that the Supreme Court is going to hear that. The Supreme Court will not hear a case to merely decide a point of law. It will not give advisory opinions, rulings on a law or action that has not been challenged. So, say you rear-end somebody, and somebody gets hurt, and they tell you, oh, we're going to sue you and take you to the Supreme Court. The Supreme Court would never hear a case like that. There's no way that that's going to happen. All right? And like it says, it will not give advisory opinions. So say this Congress is going to pass a law, and they want to get the Supreme Court's opinion, hey, is this going to be constitutional or not constitutional? The Supreme Court won't make a ruling on that. They won't provide any sort of opinion on that. They require that the case go through the proper legal process and legal procedures before they'll ever contemplate hearing it. 2. The person or group bringing the case must have suffered real harm, such as denial of civil liberties or economic loss. Plaintiffs must show that the law or action being challenged has harmed them, or that it has the potential of harming them. They have to be able to show that this has happened before the Supreme Court will ever contemplate hearing this. And if you can't show that real harm will or has been suffered, they're not going to hear the case. The Supreme Court only accepts cases that involve a substantial federal question. The court is not interested in cases that affect only the parties in the case and that do not have broader significance. So, if the ruling is only going to affect you, the Supreme Court doesn't care. If the ruling is going to have a broader impact over a greater portion of the American population, then that's the type of case that the Supreme Court is going to want to hear. And the court also traditionally refuses to deal with political questions. If they think that one of the other two branches of government can handle it and that it's their job to handle it, then they'll let those branches deal with the issue. The Supreme Court also has limits on their power to shape public policy. Cases must come from somewhere else in the legal system. The only exception to this is if it's a case dealing with an ambassador, a minister or council, or if it's or those in which a state shall be party. So if a state is being sued, that means that the Supreme Court can take that as original jurisdiction. So those are the only instances in which the Supreme Court has original jurisdiction. So the vast majority of the time, the cases that the Supreme Court hears, I would say 99.9% of the time, those cases have come from somewhere else in the legal system. Another limiting factor of the courts is their power to enforce its rulings. Lower courts can ignore the Supreme Court. Other branches of the government can ignore the Supreme Court. One of the things that you probably heard about in American history was when Andrew Jackson is told that it's unconstitutional for him to remove Indians from certain lands, and he tells the Supreme Court, go ahead and try and enforce your decision. So if the other branches of government are unwilling to enforce the decisions of the Supreme Court, then what they're saying really doesn't matter. But for the vast majority of the time, the Supreme Court's rulings are upheld and they are enforced by the other branches. Alright, so some other things, some other writs that you should know. We've already talked about the writ of habeas corpus this year, and the writ of habeas corpus is a court order requiring jailers to explain to a judge why they are holding a prisoner in custody. And then you also have the writ of mandamus. A writ of mandamus is an extraordinary writ that commands another official within the government to perform their duties. But once again, you have the issue of enforcement, that if it's not enforced by somebody else, then the writ of mandamus really has little enforcement power. All right, and one of the things that we're going to start looking at here as we get into the Civil Rights and Civil Liberties unit is the idea of the incorporation doctrine. This is a very, 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 very important concept, and it's all hinged on the 14th Amendment. The incorporation doctrine states that all of the elements of the Bill of Rights is also extended to the citizens of the state level. This is something that is brought upon by the Supreme Court in its interpretation of the 14th Amendment, and a lot of times the 9th Amendment as well. All right, because prior to the incorporation doctrine, the protections of the Bill of Rights did not extend to the state levels. It was only the federal government that was responsible for upholding those rights. So that's something that we want to keep in mind as we move through the last part of this unit and as we move into the Civil Rights and Civil Liberties unit.